Okay, so good morning everyone. So let's start our discussion. So my name is Lalit Soni and I welcome you all in this live session by Drishti IAS. In this episode, we will be discussing Indian Express newspaper, and as you know that it is generally said that the law is blind or कानून अंधा है, but not anymore in India. If you know, the statue of the Lady of Justice has been changed. Okay, so we will be talking about that. With that, there are other things which has happened in the, you can say, last day. Yesterday when we have left our discussion, we have seen that the Middle East is still in the chaos. We have seen that the issue with respect to Israel and Hamas is still persisting. But there was this recent development that the Hamas leader Yahya Sinwar has died. Okay, so after that also the PM Netanyahu has said that they will continue to wage war in Gaza Strip area until they are returned all the hostages. Okay, so still world is same, it is in the uncertainty, but only positive thing which has happened is that we have actually changed the perspective how we look at the law. Okay, so we will be talking about that, but today we will be discussing these three important articles, that is section 6A of the Citizenship Act has been held constitutionally valid. Okay, other than that there was certain, you can say, confusions were there which has been, you can say, sort out about the court. So we will be talking about that. Then what is click to cancel rule? We will be talking about the click to cancel rule in the, with respect to the subscription which you are taking. With respect to that, there is this new term which has been there in the news. So we will be talking about that. And then we have this Hamas leader Yahya Sinwar who has died. So we will be talking about that as well. Okay. Now, other than that, we will be looking at the practice question which was given to you in the previous lecture. After that, we will be talking about a fact of the day. Yesterday, someone has mentioned that we should talk about the FIR, first information report. So we will be talking about that today. Then we will be looking at the constitution section wherein we will be talking about the financial emergency. Okay, so let's start our discussion. Now, looking at the practice question, okay, I guess there was some confusion which we have already seen. Okay, anyways, I'll be taking that question in the next lecture. Anyway, since this question is here, we will be discussing this. The island of the Taiwan lies north to which country? Indonesia, Thailand, Philippines or Malaysia? So Philippines is your answer. This is Philippines and this is Taiwan. Taiwan, and recently it was in news because there was some you can say drill which was done by China in the Taiwan Strait over here. Okay, suggesting that they are, you can say, Taiwan is still within the reach of China. Okay, China has this one China policy wherein they see Taiwan as part of their mainland. Okay, so because of which there are certain concerns because Taiwan sees themselves as a, you can say, independent nation. Okay, so this is about this particular question. Now we can move further and see the fact of the day. Before that, we have GS Foundation courses for prelims as well as mains in offline mode in English medium at our centers. It is available at all the centers, be it Karol Bagh, Lucknow, Prayagraj, Indore. Okay, so when we are talking about these centers, you can directly visit the center, take your admissions over there. Admissions are open yet. Okay, or you can call on this number, that is 8010440440. Okay, I hope that is clear. You can call on this number for any kind of query or directly visit the center to get enrolled. Okay, now let's move further and see fact of the day. Here you can see we are talking about the FIR. It is common knowledge that what is FIR, first information report. It is not defined anywhere in the statute, be it your CRPC, IPC or the new laws. FIR is not defined, but it is said that the first time the, you can say, police officers are getting to know about a, you know, crime which has been committed, or there was this first information which has been given to the police, that is called as FIR. Okay, look at it. The first information report is a written document prepared by the police when they receive information about the commission of the cognizable offence. Now, why cognizable offence? Because police can only take the, you can say, cognizance of certain offences, and these offences are called as the cognizable offence. In the case of non-cognizable offence, the magistrate will take the you can say cognizance of the matter. Now they are saying the written document. So what happens over here, that a person who has seen you can say, let's say, robbery, he went to a police officer or the police station, he will recite the incident which has happened. Police will note it down, they will make it into a written document, and then they will get it signed by the person who has given the information. Okay, so that is why it is a written document prepared by the police. Okay, now it is a report of information that reaches the police first in point of the time, and that is why it is called as the first information report. Okay, now it is generally complaint lodged with the police by the victim of the cognizable offence or by someone else. So FIR can be registered by someone else as well, because it is just an information report that you have seen something that has happened which is against the law, and you have come and told the police that this has happened. Okay, coming to the next one, anyone can report the commission of a cognizable offence either orally or in writing. The term FIR is not defined in any law. However, in police regulations, rules, information recorded under the section 154 of the CRPC is known as the first information report. Again, the definition is not given in the statutes, but it is generally said that as per the police rules, etc., that whatever information which is recorded under the section 154 of CRPC, okay, so that will be considered as the, you can say, FIR. Now you will tell me in the comment section that in the BNS, okay, because you know that we have gone for the change in the criminal reform laws, or you can say criminal laws. So basically in which section of the BNS this section 154 or the, you can say, the version of 154 is mentioned. Okay, anyways, now this is about the FIR. FIR can be filed by a person, as I told you that it can be filed by any person. FIR can be of a cognizable offence. When it is a non-cognizable offence, it is a complaint to a magistrate. Okay, so that is there. Cognizable and non-cognizable, simple difference is that in the cognizable cases, police officers can start the investigation on their own. So these are called as the cognizable offences. Police can take the cognizance. And there is non-cognizable offences wherein police cannot take the cognizance, they have to go to the magistrate, and that magistrate will order you to inquire, go for the inquiry. Okay, so that is there. Okay, what is cognizable offence? So yes, I told you this. Cognizable offence means police do not have to go to magistrate for the initiation of the you can say investigation. Once that particular thing comes to you, or you can say that information comes to you, police can take the cognizance of that. Okay, then police will file a make a charge sheet, and then they will present in front of the magistrate. Okay, so that is there. Now coming to the next part over here. Before that, I would like to tell you one more thing over here, that there is this concept of zero FIR. When you go to a police station, they will be, you can say, writing your FIR in a register, and there will be a FIR number. Okay, so let's say there are 10 incidents which has been registered today, so there will be 10 sequences which will be there in the register. That will be the, you can say, there is a police diary which is maintained at the police station, so FIR number will be given to you. Okay, but let's see, there is some crime which has happened in an area called, you can say, there is a district in Rajasthan, that is Badmer. There is this offence which has happened in Badmer, but the person goes to Jodhpur, and then he has filed the FIR in Jodhpur. Can you do that? Yes, of course you can do that. You can go outside the jurisdiction where the crime has been committed, and you can file an FIR over there. Such FIR which are filed outside the jurisdiction, they will not be giving any number. Okay, so they will give a number that is 0. Such FIRs are called as zero FIRs. Once that FIR is filed, that will be sent to the respective, you can say, jurisdiction, and their inquiry will happen over there. Okay, so that is basically, you can say, how zero FIR works. Okay, now what happens after you file an FIR? So first FIR is there, they will make a copy of that, or they will write it down, they will get it signed by the person who has given the information, they will give a copy to the person who has given the information. Now there is a written document on the basis of which police will start their investigation. Okay, they will create a charge sheet. Then once the charge sheet is created, they will put in front of the magistrate, and then you will say the legal proceeding will start. Okay, if prima facie looking at a particular, you can say, information, it looks like that there might be a possibility that crime might not have been committed. Okay, so police will inquire about it, and then if there is no crime, they will prepare a final report, that is FR, that final report will mention that there was no crime which was reported, and again this report is to be given to the magistrate that there was no crime, we have gone through the FIR. Okay, so that is the proceeding after the FIR. I hope that is clear. Now we can move further. We will be talking about the constitution and the financial emergency. We were here on the part 18, that is emergency provisions, article 352 to article 360. Okay, so now we have discussed already article 352, we have discussed article 355 and 356. Now today we will be discussing the financial emergency. As I told you, there are three type of emergency: 52, 56 and 60 they are mentioned. Okay, one is your national emergency, that is there in the 352, then president's rule or the state emergency, that is there in the 356, and then we have financial emergency, that is there in the 360. Now we have talked about the first two. Now today we will be talking about the financial emergency. There is nothing much to discuss in the financial emergency, just let's go through the provisions over here. Article 360 is saying that if there is any situation that has arisen can threaten the financial stability or the credit of India or any part of its territory, the president is empowered to proclaim financial emergency. If you think that economy is having some kind of problem, okay, and you are not able to provide the salary, etc., or there is this liability which is increasing or that will impact the, you can say, credit score, all these things with respect to the territory of a country or the whole country. Okay, in such situations, president has power to go for the implementation of the financial emergency. So there will be a proclamation that financial emergency has been, you can say, put into picture. Now it is important to note that the satisfaction of president to impose financial emergency comes under the ambit of judicial review. Okay, so decision which, or you can say this discretion which has been given to the president, again this is not the discretion of president, that is the discretion of the council of minister. Council of minister will decide, they will advise the president, and president will go for the implementation. Okay, so when we are talking, most of the discretions which are given to the president, these are not, you can say, discretion in true sense. Okay, now president has only the situational discretions. Okay, when there is this when no party has come up with the majority, okay, and then you have to invite someone to form the government, that is called as the situational, you can say, discretions. There is no constitutional discretion which is given to the president, that there are certain things which are mentioned in the constitution wherein president has the discretion. That is not the case, because in all those cases president has to go for the aid and advice of the council of minister. In the case of the national emergency, you have to rely on the advice of the cabinet, and that should be written. Okay, so that is about it. Now moving further, here you will be seeing that financial emergency, there is this approval and the duration. When we talk about the approval over here, so we have seen in the case of the national emergency, approval is 1 month. State emergency or president's rule, the approval was 2 months. Within the 2 months you have to get the approval. In case of the financial emergency also, there is this approval of 2 months. You have to get the approval after the proclamation has been put in place. Within 2 months you have to pass it by the both the house of the parliaments. Okay, now once it came into picture, or once it came into force, the financial emergency must continue indefinitely till it is revoked. You do not have to go for the approvals again and again. When we were talking about the national emergency and state emergency, you know that after 6 months you have to get the approval done from the parliament again. But in case of financial emergency, you don't have to do that. Okay, moving further, revocation of the financial emergency. So obviously president will go for the revocation. Revocation of financial emergency is also done by the president within a subsequent proclamation. Okay, so moving further, we will be talking about our topic of the discussion, that is we are talking about the section 6A of the Citizenship Amendment Act. The, you can say, constitutional validity of this particular act was challenged in the court. Okay, and court has come up with some kind of conclusions over here. The majority. Okay, in case of national emergency, the majority is special majority. When we are talking about the state, you can say, emergency or the president's rule, the majority is your simple majority. Okay, I hope that is clear. Now coming to the next one, that is 6A of the Citizenship act that is valid, that has been set by the Supreme Court, and that was a majority decision. 4:1 decision was there. There was one judge who was saying otherwise, but we will be looking at their opinion as well. Okay. Now, when we talk about the section 6A of the Citizenship Act, that is talking about you can say there are certain people who will be given, you can say, citizenship of India. They are from Assam. When we talk about the partition, that has given a lot of troubles to us. Okay, with respect to the dates, with respect to the, you can say, benchmark dates which are given. So here you can see, when there was this partition, you know that in the constitution there was this date which was mentioned that after before that everyone who has come into India, that will be the citizen. Okay, when we talk about the source of citizenship, in India where we are having two sources. One is basically your constitution. At the time of the commencement of the constitution, there were certain provisions which has said that at the time of you can say commencement, these category of people can be the citizens. Okay, and these will be the citizens just because they were resident of India at that point of time. Okay, they have also made these provisions that a person who has come within this to this date from Pakistan, or who has came to Pakistan, returned and then came back. So all these provisions are given in the, you can say, constitution. But constitution gives you a limited, you can say, provisions. Only 3 to 4, 5 provisions are there in the constitution. But after that, the second source is your Citizenship Act. Okay, the Citizenship Act of 1955. Now with this particular, we are citizen of India by the virtue of this particular act, Citizenship Act of 1955. Okay, so now coming to the 6A. Now this 6A is related to Assam. We will be seeing what is 6A, what you can say confusion were there, what were the contention, all these things. Right now just focus on the headline. 4:1, Supreme Court upholds the citizenship provision for migrants to Assam from the East Pakistan. You know that 1971 was the time when in Pakistan, East Pakistan, when we know talk about the, you can say, India and Pakistan, you know that we have Bangladesh somewhere over here. Okay, so this is the Bangladesh, this side we have Pakistan. Okay, so there was this East Pakistan and West Pakistan. In 1971 there was this you can say war of independence which was there over here, and India has supported them, and ultimately the East Pakistan became the Bangladesh. But during the war, or you can say when there was this Mukti Wahini, Mukti Jodhas which were fighting for the independence, at that point of time the East Pakistan's you can say forces, they were driving them away. Okay, so because of which there are many people who has migrated from Bangladesh, or you can say that times East Pakistan, to, you can say, northeastern region, and most of them has gone to the Assam. Though West Bengal has a good amount of boundary with them, but still they have actually settled in Assam. Most of them they have migrated to Assam. The local Assamese people had the problem with that, because now they are thriving on their resources. Okay, so those migrants who has came from outside, now they are thriving on the resources of the local communities. Okay, because of which there was very concerns were raised over there. And after that, somewhere around you can say 76 or something, there was this struggle which started, which is against the, you can say, in 1979, if I am not wrong, in 1979 there was this All Assam Student Union and other organizations were also there. They started you can say protesting against the migrations, etc. And then later on we have come up with the, you can say, 1985 there was this Assam Accord. Okay, so that was there. So considering all these things, there was this two, you can say, benchmark dates. One was given in the Assam Accord and one was given in the Citizenship Act, that is section 6A. Now let's see what has happened and what was the decision. Okay, upholding the constitutional validity of section 6A of the Citizenship Act 1955, which essentially sets that March 24, 1971 will be the cutoff date for the entry into Assam for granting the citizenship. Okay, so see here, March 24th, 1971. Now that will be the cutoff date that was given by the section 6A of 1955 Act. Okay. Now they are saying that everyone who has come before this particular date will be given the citizenship. Okay. Now the problem was that the local people was not happy with this particular issue. Then you know that in 1979 there was this protest which was there for 6 years, and in 1985 they have come up with the Assam Accord. Okay. Now this Assam Accord says that they have actually gone for a date which was there in January 1966. Okay, they have also made provisions for the people who has came between January to March. That was they have mentioned that, but the thing is the benchmark date was decided, that is 1966. Now because of which there was this issue which has been there, that which cutoff date would be there. Okay. Now let's see what was the issues over here. Here you can see Supreme Court Thursday called a stricter implementation of the law against the illegal immigrations, judicial monitoring of the implementation of the immigration and the citizenship legislation. That was the direction which has been given by the Supreme Court. Now let's see what is the issue over here. The Assam Accord, Clause 5 and citizenship. Okay, 1979, all Assam Student Union began an agitation demanding that identification and the deportation of the illegal foreigners predominantly from the Bangladesh. So they have started this agitation that saying that those people who has came from Bangladesh, they should be identified and detained back to Bangladesh. Okay. Now predominantly from the Bangladesh, the agitation went for the 6 year, culminating into a historic Assam Accord that was there in 1985 between the central government, state government and the leaders of Assam movement. Okay. Most prominently they were the all Assam Student Union. Okay. Now coming to the Clause 5. Now Clause 5 of the Assam Accord, which is saying that the foreigners issue, which is discussing with respect to the foreigners issue, and set the January 1st as the cutoff date, January 1st 1966 as the cutoff date. We have seen that in the section 6A of the Citizenship Act, this was 24th March 1971. Now here they have set this as the benchmark date, okay, as the base date and the year for the purpose of the detection and the deletion from the electoral rolls of the foreigners. Now one thing which is important over here is that they said that this is the date for the foreigners to be getting out of the electoral roll. Now you know they are trying to detect you and then getting the name or deleting the name from the electoral rolls. Okay, so they are not still detaining them or sending them back, just that they are getting them out of the electoral roll so that they cannot vote over here. Okay, so from the electoral rolls of the foreigners, now those who arrived after the date but up to March 24th 1971 would have their name deleted from the electoral rolls for 10 years, after which their names would be restored. Now there was this provision which was made that these people who has came after, you can say, January 1st 1966, but they have come before 24th March. Now why this 24th March was selected as a date? Because that was given in the, you can say, section 6A of the Citizenship Act. So those people who have come after January 1st 1966 and till 24th of March 1971, here these people will not be able to vote for 10 years. Okay, they will be given the Indian citizenship, but they won't be able to vote for the 10 years. Okay, so that was the provision which was made in the Clause 5 of the Assam. Okay. Now here you can see in 1985, in order to give effect to the Assam Accord, section 6A was introduced in the Citizenship Act of 1955. The petitioners argued that this section was arbitrary and discriminatory in the nature, and it was applied only to Assam. Now this particular, you can say, date, right now this confusion is there because once Assam Accord was signed, for the implementation they have come up with the 6A of the Citizenship Act, and in that the date was the 24th March 1971, because they have mentioned over here in the Clause 5 that they will be having this date. After that they will be talking about the Citizenship Act, etc. So that is why in 1985 when the Assam Accord came, and after that there was this implementation, at that point of time the people, local people, said that you can say these people are outsiders and they are being given the citizenship and they will thrive on the resources. So that is why they have said that this particular provision is arbitrary, okay, and invalid. Now after that there was the CAA, etc. Right now we are not going into details of that. Right now just know that there was this confusion with respect to the two dates. Okay, this was the date that which was there with respect to the Assam Accord. Okay, this was the date which was there with respect to the 6A of the Citizenship Act. Okay, now they reached the court and said that which of the, you can say, date is valid. Second thing, if you are using this particular date, that is arbitrary in nature, okay, and that should be held unconstitutional. So court over here is said that you can say, you can go through this particular site, there are certain statement which was made by the justice, but we will focus on the decision over here. Court over here is said that those people who has come before 1st January 1966, these people will be the citizen. Okay, they are citizen, no doubt is there in that. Okay, after that, those people who were there between this particular time, that is from 1st January to 24th March 1971. Okay, so these people who has come within this particular bracket, they can become the citizen. They can get the citizenship, okay, but for the 10 years they won't be having any kind of right with respect to the votes, because their name has been deleted from the electoral roll. Okay, so that was there. And those people who came after this particular point of time, okay, so after 1971, these people will be tried. They will be tried by the, you can say, foreigners tribunal, and then they will be decided that they will stay here or not. They have to go for the normal procedure for getting the citizenship. Okay, so that is what that is there in the, you can say, this particular issue. Supreme Court said that this is the right now, this is the situation. The act or the clause of the act or Assam Accord, these are not invalid, they are valid. Section 6A of the, you can say, Citizenship Amendment, Citizenship Act 1955, that is basically, you can say, valid and constitutional. Okay. Now here you can see section 6A was introduced in 1985 following the signing of the Assam Accord between center and the agitation group which was there in state. Clause 5 of the Assam Accord stated that January 1st, 1966 would serve as the base cutoff date for the detection and the deletion of the foreigners, but it also has the provisions with respect to the regularization of those who have arrived in the state after the date, that is up to March 24, 1971. Okay. Now, why this date, March 24, 1971? Because that was the time when the, you can say, they started this you can say Mukti Jodha movement, or you can say independent Bangladesh movement has started, and after that there was people who has been you can say persecuted from that particular place, and they have came to Assam. Okay. Now, section 6A is not violative of article 6 or 7 of the constitution. Article 6 and 7 is giving you a date, cutoff dates with respect to the, you can say, those people who has seen the partition and those who has settled in India. Okay. So that they have which prescribe a cutoff date for the conferring citizenship for the migrants from the East and West Pakistan at the commencement of the constitution is January 26, 1950, at the date of the commencement of the constitution. Okay. So they the, you can say, the people who has reached the court, they are saying that why is that they are having a different dates. Okay. Then there is this cutoff date which is given over here. So court has said that there was, you know, some you can say the situations were there that he had to go for this. The legislative objective of the 6A was to balance the humanitarian needs of the migrants of the Indian origin and the impact of the migration on the economic and the cultural needs of the state. So we have to maintain a balance between the, you can say, humanitarian needs and the cultural and the economic effect which that migration will have on the local people. Okay. Though other states share a greater boundary with Bangladesh, the impact of migration in Assam in terms of the number and the you can say sources is greater. Thus, the yardstick for the migration to Assam is reasonable. The cutoff date, that is of March 25th, 1971 is reasonable because Pakistani army launched the Operation Searchlight to curb the Bangladesh nationalist movement in East Pakistan on March 26, 1971. Okay. So on 25th they have started the Searchlight, and on 25th, 26th they have started the, you can say, Operation Searchlight. That is why the cutoff was kept 24th of March. Okay. So this is what has been given in the decision. Okay. Finally, if you want, here you can see petitioner's contention was that it is violative of the constitutional principle, whatever principle are there in the constitution, so it is against that. Then second is the fundamental rights are being, you can say, impacted. So the fundamental rights, that is article 14, right to equality, why should there be different cutoff date for different people, that is there. Article 21, right to life, and article 29, that is cultural rights. Cultural rights are getting hampered because obviously the migrants are coming over there and they are, you know, obviously they are bringing their own culture as well, since there can be a dominant you can say majority over there or they can be having this dominant sway on the culture of that. That is why there was this issue of cultural rights that has also been raised, but court has said that there is nothing to be worried about, and they will be going for the monitored implementation of this particular thing. Now migration classifications. So before January 1966, this is the most important para for you. This is the crux of the judgment. Before 1966 January 1st, people will be deemed as Indian citizenship. They will be having the Indian citizenship if you have come before this particular date. Between 1st January 1966 to March 25th 1971, then you are eligible to get the citizenship, subjected to eligibility. And after March 24th, because 24th is the benchmark, so after that, that is basically 25th 1971, classified as the illegal immigrants liable for the detention and the deportation. Okay, so that will be there. So that is about it. Now we can move to the next part. Achha, one more thing. I have told you that there was this judgment that is 4:1. So there was one person or one judge which has a dissenting opinion, which has the, you can say, minority opinion. So we'll look into that as well. The constitutionality over time. He has said that when this particular, you can say, clause was entered, that was fine. At that point of time, it was valid. But now, looking at the poor implementation, etc., that is not valid to go forward with the same. Okay. Then next is arbitrariness in the today's world. That is arbitrary, because at that point of time we had the reason, but now if the implementation is not there, then obviously it is of no use. Okay, so that has been said by the Justice Pardiwala, but again this was a minority opinion, so it does not matter. Okay, now moving further to the next article, that is basically talking about what is the new click to cancel rule announced by the US FTC. Okay, US Federal Trade Commission, that is talking about the click to cancel. You can go through this particular article because it is given in the simple language, but I will try to make you understand what is click to cancel. Now there is this application which you have downloaded from the Play Store, that is saying that you have a 1 month of free trial. Okay, 1 month free trial, but when you are logging into it, they are asking you about your credit card details. They are saying that we will not charge you right now, but you have to enter it. Okay, so you entered the credit card details, you said that they are anyways not charging anything, and then you have moved further. You have used it for 1 month, and on the end of the 1 month, or you can say the first day of the next month, they have charged you a decent amount, let's say some $25. Okay, they have charged you $25 on the first day of the next month, because the trial period is over. Okay, they have already taken the credit card details. Okay, so that is basically called as the negative. There is this term, that is negative option program. Negative option program, that means that there is no option which is given on the last date that you have to go for the cancellation, or there is no automatic cancellation. Okay, what is there? That is automatic renewal is there, but not automatic cancellation. So that is called as the negative option program. That is, you are not having this you can say option to go for the cancellation of the subscription at that point of time. Okay, because it has already charged you for the next month. Now this has been a problem, because earlier there was this 40 cases which was there in 2021, and recently per day there are 70 such cases are there, and these people or these companies are basically taking advantage of this, because people might not be able to remember that this is the last day of this particular month and I have to cancel that subscription which I have taken one month back. So ultimately they are losing this amount of money which for a service which they are not even using. Okay, now the UN FTC has said that they will go for the click to cancel. Other than that also, once you have been charged $25 over here, okay, that charge has been taken for the next month. Now you have made a phone call, or you have gone to the app that you want to cancel it, but they have said that to cancel you have to call on this number. You called on that particular number for like 2 hours, they are keeping you waiting. After that they have received the call, and then they have you have told that I want to cancel this, but they are not cancelling it. They are saying that it will take 2-3 days. After 2-3 days you have to call me again. So they have made the process of cancellation tedious. Okay, because of which the client is also getting the frustration and all. So they have made it very tedious that sometimes it is with someone it is okay that okay fine, let them do, I'll cancel it next month. Okay, so now this is the thing which was there, and because of which there was this unfair practice which was culminating in the, you can say, trade world or the business. Ultimately they are getting an undue advantage of the people who are not very active or not very enthusiastic about cancelling the services, because the service cancellation itself is a tedious process. And that is why now FTC is saying that they will come up with a click to cancel option, wherein there will be a option, you will just go and click on that particular option, then your service will be terminated, you won't be getting charged anymore. Okay, so that is there with respect to the click to cancellation. US Federal Trade Commission FTC has said that they will be soon implementing click to cancel rule, which will make it significantly easier for the consumer to cancel their subscription, and the membership make companies liable to face civil penalties for complicating the cancellation process. If you are making the cancellation process complicated, then also you are liable for that. Okay, moving further, there is this endless hoop just to cancel a subscription. As I told you that you have to click on this number, you have to call on this number, you have to be in the waiting line, then you will there are sometimes they will not even receive your call. Okay, they will say that there is a waiting list which is too long, that you are not getting the number. So such things are there. The FTC's rule will end these tricks and traps. Nobody should be stuck paying for a service they are not using, or they are not there to want. Okay, now what does the new rule says? That sellers will be required to make it easy for the consumer to cancel their enrollment, as it was easy to sign up. Okay, so that is there. Companies cannot require people to talk to a live or virtual representative to cancel if they do not have the if you do not have to do that for the sign up. For the sign up, if you have not talked to anyone, then why at the cancellation you should have to call on a particular number and then ask them to cancel the service? That should not be the case. So obviously they have said that there will be a button, then you can cancel it. Okay, companies cannot charge extra for the phone cancellations. So if you are calling a number and they are charging for that as well, so that should not be the case. Okay, for subscription that were originally offered in person, companies cannot mandate that in-person cancellation should be there. Let's say there was this you can say LIC. Okay, in person you have went there, you have gone for the checkup etc, then you have gone for the policy, you have taken the policy. Now you have taken the policy in person, you have subscribed for the policy in person, you have taken the membership in the in person, but if you want to cancel it, there should be an option on the website from where you can cancel it. Okay, so that is what it is saying. To whom will the rule will apply? So for everyone who is having this negative optional program, or anyone who is charging this way. Okay, for that this rule will apply. You can go through this particular thing. Why was this rule brought? As I told you, the incidents were increasing. Okay, so somewhere over here it is mentioned that in 2024 the daily complaints regarding the negative option feature, there was nearly 70 from 42 in, you can say, 2021. Okay, so that is why they have gone for this particular thing. In the future you will be seeing that. Okay, moving further, wildlife board differs not for the Vedanta's oil exploration in Assam. So in Assam there is this Huluk gibbons which are there. When we talk about India, okay, so it is India's only ape. It is India's only ape species, and these are shy of the contact. Okay, they are found in Assam. There is this Huluk gibbon sanctuary as well. Okay, in the vicinity of that there is this Desoi Reserve Forest. Okay, in Desoi Reserve Forest also they are found, and these particular you can say project of Vedanta's oil exploration that was there, they wanted to go for the oil exploration in that particular area's vicinity, and right now they have deferred from the north. They have said that we will go for the site visit first, and then we will look at the impacts, and then we will talk about it. Okay, so that is one thing which has happened. Other than that, there are certain things which is there. So first thing is your Huluk gibbon, that becomes important for you. Second thing is Desoi Reserve Forest. Other than that, there is this Huluk gibbon sanctuary. Okay, so you can remember that. So there is this another proposal that they have cleared a proposal to electrify a section of existing 100-year-old broad railway line passing through the sanctuary in Zorhat, subjected to the construction of the animal passage. So they will go for the you can say electrifying of the railway line, but there is this animal corridor which will be made first. Okay, For these Gibbon also, they are saying that they have to make this Ariman corridor or the Gibbon corridor, wherein they will go for the artificial tree canopy, etc. Okay, so that is there. Now they have also cleared a road widening through the buffer zone of the Ramgarh Vishdhari Tiger Reserve in Rajasthan's Bundi. Okay, so that Ramgarh Vishdhari is there in Bundi in Rajasthan. So for there also they are going for the, you can say, widening the stretch of the road over there. So you don't have to remember that what they are doing over there. Just know that these sanctuaries were in the news, and that is why that becomes important for your examinations. Okay. Now moving further, the Hullo gibbon is India's only ape species and shy, and as I told you, and they are only you can say, when we are talking about number, they are only 120 to 130 in number in India. Okay, so that is also you can say the concern, because of which you have to make sure that there is the all the proper provisions are there with respect to the conservation and the habitat protections. Okay, so there is this Holangapar Gibbon Sanctuary. Okay, this Holangapar Gibbon Sanctuary is basically the one sanctuary. Holangapar Gibbon Sanctuary. Okay, so that is there, and other than that, we have seen that there is this Desoi Forest Reserve, which is there, and that is there in the vicinity of this Holangapar Gibbon Sanctuary. Okay, we have talked about this oil exploration project, which is there. Last month, the Environment Ministry's Forest Advisory Committee, they have actually given a nod for the, you can say, exploration, but now here you can say this standing committee has said that they will go and inspect the site first. Okay, so I hope that is clear. Other than that, this already we have discussed. Now moving further to the next one, that is October 7 attacked architect Sinwar killed. Yahya Sinwar. Sinwar. So this particular person was behind the October 7th attack on the Israel, because of which all this issue has been there. So recently he has died. Okay, so here you can say a good day for Israel and US, and the world, says President Biden. Okay, the Israel military ran a DNA test before announcing the death of Sinwar. Okay, Netanyahu says will continue operations in Gaza until hostages are returned. Okay, so this is something which has happened. You don't have to go into details of it, that how it was you can say killed, what kind of strike was that. That is not necessary for you. Just know that that has happened. There are 3 more leaders to go. Actually, this is something funny that this person has died and they have given another list for that. Anyways, moving further, for the passing reference, as I told you, the new Lady Justice. Earlier we had this picture of the Lady Justice, where was a sword was there in the, you can say, one hand. She is over here having a leg on a particular book over there, and then this is the way. Okay, and there was this blindfold which was there on the eyes. Now you know that we are going to go for the change in the nomenclature and the colonial legacies, etc. We are trying to change the way we have looked at the things. So now we have come up with the new picture over here, that is, in this hand she is holding a book, that is the Constitution. The weighing is there, and then she does not have the blindfold anymore. Okay, so now in India the Kanun is not Andha anymore. Okay, so that is the good thing. You can see. Now for your own read, there is this article, why researchers studied a marine temperature in the twilight zone. Okay, so this article you can go through. Okay, it is something to do with the, you can say, climate change and the warming, so you can go through it. Okay, in the end we have this question for you: what was the purpose of section 6A of the Citizenship Act 1955? Option A, to provide citizenship to the all immigrants from Bangladesh, to remove all illegal immigrants from India, to provide a legal framework for certain migrants to seek Indian citizenship in Assam, and to grant citizenship to all immigrants who has entered India before 1971. Okay, so you can attempt this question and answer to me in the comment box. With that, I would like to take your leave. I'll see you in the next episode. Till then, have a good day. Thank you, and see you on Monday.